From January 2011, Australia has a single national consumer protection law, the Australian Consumer Law. As part of the Competition and Consumer Law, the Australian Consumer Law replaces the previous consumer provisions of the Commonwealth Trade Practices Act and State and Territory Fair Trading Acts. The Australian Consumer Law is all about safe products, fair contracts and sound sales practices for all Australians wherever they live and work.
While these laws mean new protections and clearer rights for customers, there are also benefits for business. For a start, it means one set of rules for business instead of over 17 different state and territory laws. So for businesses that operate across various states, this is a real plus.
The Australian Consumer Law, or ACL, is also intended to be clearer, putting in black and white and plain English trader obligations and consumer rights to increase certainty for all.
As well as applying to all purchases of goods and services for household use, the ACL also applies to goods and services for any purpose, including business use for items costing up to $40,000. This will give small business in particular clearer rights when dealing with other businesses for common purchases. Some of the key elements covered in the ACL include protections against unfair contract terms, consumer product safety, guarantees and refund rights, sales practices including door-to-door sales, telemarketing and lay-bys. There are significant penalties for breaches of the new law. These penalties are expected to provide a much greater incentive for compliance.
We want to help you be aware of your obligations under the Australian Consumer Law and where to go to find out more or keep up to date.
A contract is an agreement between two or more parties that is intended to be legally enforceable. A contract can be in writing or made orally and can be entered into by signing a document, agreeing to something on the telephone, or clicking I agree on a web page.
The Australian Consumer Law introduces new laws relating to unfair contract terms. It provides more protection for consumers entering into standard form contracts.
A standard form contract is usually one that has been prepared by one of the parties and is not subject to negotiation. It's offered on a take it or leave it basis.
Standard form contracts are used by many industries. These are normally printed out ready for signature, and there is little or no scope for negotiation.
In any dispute over whether a term of a contract is unfair, the court will generally consider three factors.
Whether it would cause an imbalance in the parties' rights and obligations, whether it is necessary to protect the interests of the party who is advantaged by the term, whether it would cause detriment if it was enforced.
Examples of standard form contracts include gym memberships, airline ticket purchases and mobile phone contracts. It's important to note that the new unfair contract term laws do not apply to the supply of goods and services or financial products from business to business.
The Australian Consumer Law includes a national product safety regime. It sets out the responsibilities of Commonwealth, state and territory governments, and it deals with the responsibilities of suppliers.
This law allows Australian governments to regulate consumer goods and product-related services through a number of initiatives that will ensure product safety. The law describes the responsibilities of suppliers, providing guidance on what to do in situations such as when a ministerial ban is issued, when consumer goods need to be recalled, when an incident needs to be reported, when manufacturers may be liable.
As part of the new mandatory reporting requirements, suppliers will be obliged to report consumer goods or product-related services associated with death or serious injury or illness of a person.
The new product safety website carries information on the national bans and standards, www.productsafety.gov.au. If this relates to your business, you can sign up for the Twitter feed and get all the product safety updates.
Consumer guarantees apply to goods and services purchased from a supplier or a manufacturer by a consumer on or after the 1st of January 2011.
They apply to any type of goods or services costing up to $40,000. Goods or services costing more than $40,000, which are normally used for personal, domestic or household purposes. A vehicle or trailer, and the cost of the vehicle or trailer is irrelevant to your right of a guarantee.
When you provide goods and services to consumers, you automatically provide certain guarantees, regardless of any other warranty. So who gives the consumer guarantees?
Consumer guarantees are provided by the supplier, who is the person or business that sold the consumer the goods or services, or it can be the manufacturer, who is the person or business who made the goods, put the goods together, has their name on the goods, or imported the goods if the maker does not have an office in Australia. Both supplier and manufacturer guarantee the goods are of acceptable quality. They must be safe, durable and free from defects. And they must do the job such things are usually used for. These guarantees apply to sale, hire or lease agreements. There are a number of other guarantees required of suppliers, including their right to sell the item, and that the item is fit for the disclosed purpose. The item must match the description given to the consumer or match the sample or demonstration model. A supplier guarantees to provide services with due care and skill, including an acceptable level of skill or technical knowledge, and takes care to avoid loss or damage. There is also a requirement that the services will achieve the result the consumer was told it would, and within a reasonable time. A manufacturer guarantees the availability of repairs and spare parts.
And both manufacturers and suppliers must also honour any warranties against defects.
If a good or service fails to meet a guarantee, a consumer will have rights against the supplier and, in some cases, the manufacturer. He will have to provide a remedy. That is, an attempt to put right a fault, deficiency, or a failure to meet an obligation. For a minor failure, the supplier can remedy the problem by repairing, replacing, or giving a refund. With a major failure, the consumer can choose a replacement or refund, or ask for compensation for the drop in value of the goods or services.
Consumer protection agencies may also take legal action when a supplier or manufacturer fails to meet their obligations under the consumer guarantees.
Lay-by rules are included in the new Australian consumer law. The practice of lay-by is common, but it hasn't been uniformly regulated until now.
A lay-by agreement exists if a consumer pays for the goods in at least 3 instalments when the agreement is not called a lay-by agreement, or in 2 instalments when the agreement is called a lay-by agreement, and does not receive the goods until the full price has been paid. Lay-bys must be in writing. Then there are further requirements to protect the customer. Written terms and conditions expressed clearly. A copy of the agreement to the consumer. And the consumer can cancel up until the goods are delivered.
An example of a lay-by agreement could be a Christmas hamper ordered in advance and paid for in weekly instalments over 12 months. And remember, any deposit paid by the consumer is an instalment. If a consumer cancels an agreement, a supplier must refund all amounts paid by the consumer under the agreement, although the supplier can charge a cancellation fee.
Unsolicited consumer agreement provisions relate to any agreements arising from uninvited contact with a consumer, for example, door-to-door sales or telemarketing contact. The law provides a 10-day cooling-off period for door-to-door and telemarketing sales.
Consumers who sign up to unsolicited agreements are given 10 business days to reconsider the deal, during which they can cancel the agreement without penalty. This is called a cooling-off period. If a consumer cools off in writing, they are entitled to a refund of any money paid under the agreement.
The Australian Consumer Law sets out the allowable hours of calling for door-to-door and telemarketing sales.
Under the new laws, door-to-door trading is now prohibited on Sundays or holidays, before 9 on any day, after 6 on a weekday, and after 5 p.m. on Saturdays. Telemarketing is also regulated under the Commonwealth Do Not Call Register Act 2006. This prohibits calls or faxes to consumers on Sundays and public holidays, before 9 on any day, and after 8 on a weekday, after 5 p.m. on a Saturday. Calls continue to be banned from consumers who are listed on the Do Not Call register, www.donotcall.gov.au.
The law requires that certain information is provided to consumers by door-to-door salespeople and telemarketers.
The consumer can still call off, and there needs to be a written contract for the consumer. No contact during calling off. Be upfront about the purpose of the visit. Inform the consumer that they can ask the supplier to leave. Supply written information about calling off.
The ACL includes a range of prohibitions in relation to making false or misleading claims or representations about the supply of goods and services or in promoting the supply of goods and services. The law prohibits false and misleading testimonials.
Testimonials are commonly used in advertising, using previous customers or celebrities to endorse the product or service. The legislation protects consumers from misleading representations in testimonials. Advertisers need to make sure testimonials are true and correct when using them to endorse products.
The Australian Consumer Law provides a single set of provisions about safe products, fair contracts and sound sales practices, so the ground rules are clearer for consumers and traders wherever they live and do business.
The best source of information is the new National Consumer Law website. To be fully prepared to meet your obligations and to keep up to date, go to www.consumerlaw.gov.au.